operating a motor vehicle on Telegraph near Holbrook and Brownstown Township, February 17 to 25 at 10:23 in the morning.
Yes,
Did you drink alcohol prior to that?
yes.
What did you drink and how much?
Vodka and 13 drinks the night before,
What time did you take your last drink?
probably around 3:50 in the morning.
Are you on probation or parole?
No,
And you're 19?
21.
I'm sorry. You were 20 at the time.
Yes,
Anybody force you to plead guilty?
no,
Anybody promise you didn't do you plead guilty?
no,
Why were you pulled over by the police?
because I was in an accident.
How did the accident occur?
I failed to stop. We were at a semi.
All right, you think you did that at least in part because of your alcohol consumption?
Yes,
The council, you stipulate that the blood breathalyzer results were 0.155.
Yes,
Has anybody forced you to plead guilty?
No.
To the charge of distracted driving, you plead responsible or not responsible?
responsible.
And accept your plea to operating loan period.
Yes,
Going to accept your plea to distracted driving. Going to dismiss the operating loan intoxicated and failure to stop assured by the distance. Now, I'm going to refer you for a screening and assessment. I'm going to talk to you before you leave here, though. You're going to be screened and assessed today. You're going to be sentenced at a later time. We're going to set up a sentencing date. Now, Mr. Williams, I want you to listen to me very carefully. You stop drinking 7 hours earlier. That means your breathalyzer result, the time you stop drinking, is somewhere in the neighborhood of 2.6. I just want you to be aware, when I see somebody who's 20 or 21 with a 2.6, you gotta drink it. Doesn't make you a bad person. It does mean that you gotta deal with this. I'm serious. I mean, when I see guys come in here with that, the odds of you coming back to in this court or another on a drunk driving are extremely high. This is like really high. I get it's just a 155, but if you stop drinking, I'm gonna take it at your word. You stop drinking, it's 3:30, 7 hours earlier. You were about 2.6. So that's bad. I want him counsel. I don't think the rest of the buck press the panic button, but I need him on a sober lane device. One of my sober, I don't do this on first offenses, but this scares the devil out of me. You're gonna be on a sober link device by the end of the day, okay? I'm not sitting here degrading you or anything else. I'm just very, 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 very concerned. You understand what I'm saying to you?
yes,
I want to give you, have you seen proof of him attending AA once a week?
Your Honor, I do have a attendance sheet that has been signed
I don't need to see it. Just tell me how many times he's gone.
5 times. First one was on April 1st.
What is he doing right now? Is he going to school, working?
we do both, yes.
Where?
I go to school at Eastern. I work in Hungry Howard's in Riverview.
You work where?
Hungry Howard's in Riverview.
Are you staying at Eastern Michigan?
No, I can
What are you studying?
supply chain management.
I'm not trying to punish you. You know, how much is the cost in the missions there to Eastern Michigan?
About I believe just over maybe 8,000 a year.
Plus books?
Plus bucks and gas to get there and stuff.
You're gonna spend $50,000 probably, right? By the time you get a four-year degree?
Mhm.
Yes?
Yes.
So, I really don't. You caused me an accident. Lisa, give me a counsel. Listen, I would appreciate some help. We have a court to school program. Did you go to training?
Yes.
So I'm not gonna lie to you, it's gonna be more embarrassing. We have a court to school program coming up to Trenton High School. I'm gonna give him credit for any day of arrest, for showing there through there. I'm not saying he's going to jail. He's not going to jail. The court work program is community service. What day is that again? It's May what?
May 1st, Judge.
Can he do that? Are you willing to do that? Be sentenced at Trenton High School? I'm not gonna force you.
And so what happens when you do that? Like does it give, like what,
I'm gonna sentence you. And I'm gonna give you a day's credit toward any jail, court work, or community service. You're not going to jail,
okay,
but I'll give you another day's credit for doing this.
What, that'd be May 1st, and what's that?
At least, Amy, what time does that start again?
9 a.m.
I'm sorry,
9 a.m.
9 a.m. So I need you there by 8:30.
okay.
Can we, is there any other dates available? I've got 4 matters scheduled for the morning.
Do you?
Yeah.
I mean, I could give you another date. I just need people on the court to school program. That's all.
Yeah.
You don't have anything. Where do you gotta be? What's the
They're all
earliest?
Zoom hearings. One at 8:30, one at 15, one at 10, one at 11. Zoom.
Can you do your 8:30 and then do the court to school? I'll get you out of there first. I get it. Okay, we'll give you another, give me another date, Amy. Probably on a Brownstown day.
Judge, we can do nope, that's May 7th at 8:30.
Is that good with you? If it's not, it's okay. with you.
Yeah, I've got a 9 o'clock settlement conference in Macomb.
Okay, good to see you so busy.
It's just been crazy. Last few months.
What do you want? Can we do the 14th, Lisa? Amy? Jeez.
Yep, we can do the 14th, or we can cross over on April 30th.
Whatever your choice, Council.
Yeah, 14th at an oral argument in Michigan. You know. 30 of them. Litigation, 9 o'clock.
It's okay.
Is May 8th available?
This is a case of possible restitution. I doubt it, but maybe.
Yeah.
And I always set it on a Brownstown docket day, so it almost has to be a Wednesday.
May 21st,
Yeah.
wide open.
May 21st at 8:30. Sure, you can go down the hall and screen assessment, right? Go 8 times a week. Yeah, lunch.
Would that be here or is it?
No, we'll do it here.
Okay,
Yeah, I
you
can't.
mentioned the school.
Well, that's the only day, I just do it at the school once a year.
Oh,
That's the one that was made the
right.
first. So yeah, you're gonna go across the hall, you're gonna fill out a questionnaire, you need to give them a sober link. You need to get a sober link by the end of the day, and I want you going to AA 3 times a week. I'm not looking to punish you, but you gotta be careful here.
And what is it sober link?
It's a machine you're gonna have to blow into 5 times a day. Okay? All right, good luck to you. I wish you well. And you're all set.
Thank you.
Thanks a lot. Good to see you. Council. That sign, John, keep that, Mr. Shelby. Romero. People against, Hero, Francisco Romero, 25 WHA, B.
What's it for?
19F2309998. A, B, and C. Name?
Ramiro Romero. Good morning, everybody.
Good morning. So you have an expired plate.
Yes.
You have a drivewall suspended charge.
Yes.
You have a expired plate charge. You have the right to a lawyer. You also have failures to pay on the no insurance, $317 plus a clearance fee. You also have a driver with an unregistered vehicle charge for 2019. You also have from 2019 improper plate charge. I'm just gonna give you a lawyer. You talk to the lawyer. And then either way you're coming back in front of them, okay?
Yes,
So you can go right off the home. Thank you. Equal against Darnell Clark. Darnell Benjamin Clark. 25W83766A. EMC. Good
Good
morning.
morning, Your Honor. This is Rashevsky appearing with my client. Motion stands for immediate left.
Darnell Clark.
So we have an operating while intoxicated charge. And yes. Do you have the stipulated, do you have the, John? Do you have the advice and rights form back?
It's, yes, Judge, it's up back.
I thought you just were walking over here, weren't you?
No. Wait, what?
Yeah. So, it looks like he's gonna plead guilty to impaired driving. He's gonna plead, the improper lane use and OWI will be dismissed. What happened with the defective equipment?
It's a warning, Judge.
Oh, it is not, it's a civil infraction.
I thought on the ticket, I thought that
The
it.
check waivable.
Okay, Judge, it's been fixed, so I can take that back to the prosecutor and get that.
You're gonna do that.
No problem.
Okay.
Yeah,
Sure can. So we're gonna begin to see, Paul Robert LeBeau, 25W838, Your name?
All of them.
Alright, sir. Are you his dad? What's your name? So I'll let you stand there, but you can't really help him. I just want to be clear about that, okay? So you're charged with assault and you also have disorderly conduct in an MILB. I'm gonna get you a lawyer and you're gonna talk to the lawyer. And then, pardon?
I would like to talk to a lawyer.
And then you're gonna come back in front of me either way today, okay? So out in the hallway, he'll set you up with a lawyer. And he'll come back in front of me, okay?
Thank you.
Thanks. Calling Darnell Clark. Darnell Benjamin Clark, 25W76868 E and C.
Good morning, Judge. This is Rashevsky appearing with my client stands for my left. You state your name once again, please.
Darnell Clark.
So he's gonna plead to operating while impaired. We're gonna dismiss the OWI. The improper lane use violation.
That's correct, Your Honor.
Is that what you want to do, Mr. Clark?
Yeah. Yes.
If you plead guilty to this charge, the possible penalties on the impaired are up to 300 fines, 93 days jail, 360 hours community service, but costs of all those 4 points, license suspension or revocation. In accordance with your record, your vehicle could be or might not be immobilized depending upon your record. Do you understand that?
Yes.
Would you sign, read, and understand the Offensive rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
Any questions before we go on?
No, Your Honor.
The charge of operating while impaired, sir, how do you plead?
Guilty.
On February 8 or 25 in the morning, were you operating a motor vehicle on Allen or Greenland and Whiting?
Yes.
Drink alcohol prior to that, and what still where did you drink it home on?
Yes. We've had a couple of drinks.
What kind of drinks?
Hennessy
Where'd you have those drinks?
at the house.
All right, and that's in Detroit.
That's at my girlfriend's house. We stay like 3 minutes from here.
Okay. And was your ability to operate that motor vehicle impaired due to the consumption of the alcohol?
Yes,
In what way? Why were the proposal by the police?
they said I swerved.
Do you think you swerved?
Yes,
You think you swerved at least in part because of your alcohol consumption?
yes,
And you took a breathalyzer at the police station, right?
correct.
Do you stipulate that the results were 0.115?
At the scene and then .105 at the station, but yes, both over .08, Judge.
Are you on probation for the role right now, sir?
No,
Anybody who votes for
Oh,
should plead guilty or promise you should plead guilty?
no,
Please accept the charge of applicable impaired. The OWI is dismissed. I'm gonna refer you for a screening and assessment. We'll give you a sentence date. You're gonna go down the hall, get your sentence date. We're gonna give it to you now verbally, but then you go down the hall, get that piece of paper, then over at probation, where you'll fill out a questionnaire and be interviewed, okay?
thank you.
All right, what day are we gonna do, Amy?
April 30th at 9:15.
Is that good?
Yes, it is, Judge.
April 30 at 9:15 a.m. Okay? Any questions, sir?
No,
I'm dismissing the defective equipment, dismissing the improper lane use, and dismissing the OWI, all pursuant to stipulation, okay?
Thank you, Judge.
Have a good day. Thanks. Good luck, sir. Thank you. Fields? People against Eric, or Trent Fields Junior 25W375108. B 3W8232779A. Here. How old are you?
I'm 27.
When are you gonna grow up? I'm serious. I hope you got some money today. Cause I'm not gonna play games with you anymore, okay? You got it? I give you time to pay, I tell you to come talk to me, I tell you to come talk to me. If you don't have the money, you do neither. So you're either running the Pentagon. Or you have some really, really, really important position. You know the great thing about it? I don't care if you're second in line to the presidency. You got what I'm saying? Do you?
Right,
Is this your dad?
it is.
You got some money. We even for us to have a discussion, I'll say you have to be aware right now.
Well, I didn't know.
We're gonna give you one right now. Okay? You can explain everything to him. And you guys will come in front, okay? You need to stop doing that, showing such disrespect, of course. I don't know if it's something you do routinely, but you sure have on this one.
If y'all don't know if you remember that day, but that day prior, but after me and, after we had a discussion, I came back and talked to you. And you weren't trying to hear it because you wanted to speak to the prosecutor because me and the prosecutor had miscommunication. Exactly, it was supposed to be down to one charge.
Yes.
It was supposed to be down to one charge. And I came back in here and sat and waited 2 hours to speak to you. And you didn't even,
I know what you're talking about.
that day.
I know that you pled guilty, what I'm referring to is you pled guilty to failure to pay $282. Now, let me just go back. These tickets, let's just start. July 24, 23 is the offense date. We didn't take care of the case because you didn't show up until September of 24. So that was 14 months later. And you pled allowing an unlicensed driver to drive and you pled to failure to pay $282 because you hadn't shown up for the show cause on either one of these, and I issued warrants.
Number one,
Don't listen. And I told you then to pay 40 per week beginning September 20 of 24. And I also told you if you didn't have any money to come back and talk to me. Then you didn't show up, you paid $20 on September 5. And then we issued a show cause finding in January of 25. You didn't show up for that. And I issued a warrant again. So don't interrupt me.
I didn't say it. Yeah.
Well,
That's what I'm asking. I don't know when it's my turn to speak. I don't know when you finish. That's all
I'll
I'm
tell you
saying.
about that.
Yes, sir.
I'll tell you what, okay? So we got warrants on. Warrants, see the warrants? It's everybody else's fault, right? Go talk to your lawyer, we'll get you in here. But I don't really want to hear nonsense people. And so when I give you a chance like that, not once but twice, and you don't show up and you don't take care of business, don't come in here acting like you've been put out. Go out in the hall, get your lawyer can represent you, you can tell him the whole story. And he can come in and advocate for you. And then we'll go through all this. Okay? Right out in the home, such a lawyer. Against when? When? 613. What's your name, ma'am?
Good morning, Your Honor. My name is Kim Hao Opris. I'm the Vietnamese interpreter.
Okay, so we hired you. Thank you.
Yes, Your Honor.
I'm sorry, do you have a card for me?
Yes, Your Honor.
Good morning. Thanks for coming.
Glad to be here, Your Honor.
What's that?
Glad to be here with you, Your Honor.
Well, I don't know. You're one of the few that would like to be here with me, I think. Anyway, can I have that card, please? All right, I want to make sure that I pronounce this correctly.
Yes, Your Honor.
It's Kim Howe Obris.
Yes, Your Honor.
All right. I'm gonna ask you to raise your right hand. You solemnly swear to affirm that you will make a true and accurate translation between the court and the defendant.
Yes, Your Honor. I do.
Okay, can you tell me your name, please?
Tên của mình là gì?
Tien, Tien, Tien,
Can you repeat that?
Tên mình nói tiếng Việt.
Tien,
My name is Tien, T-H,
Tien,
Tien.
Tien.
My name is Tien, T-I-E-N.
All right. You're charged with retail fraud
Cô bị cái tội này là đó.
and you have the right to a lawyer.
Cô có quyền có một người luật sư.
I think I should set you up with a lawyer right now.
Tôi có thể tôi đưa
And then you and the interpreter, a lawyer can sit down somewhere in a conference room and talk.
và có người viên cô và cái người luật sư và cái người thông dịch viên sẽ ngồi xuống nói chuyện
Okay?
nhau chứ. Yeah. Yes, Your Honor.
All right. That's good. Thank you very much.
Bạn nói đi rồi.
Yeah. Yes.
I should try to sit. Why don't you give these to Nancy?
Morning.
You one gave. Who's on lawyer this today?
Dave is overflow.
Okay, let's give a couple of these to, this is Mr. Clark, so this should probably go. Yeah, I'm gonna take this to, give one of these to Gabe. Which one's that? Yeah, give that one to Crawford, this one to Gabe.
No, Clark.
That's-
Darnell Clark can go to probation.
Yeah, Jonathan Clark can go to probation.
And if whoever's going to Mikkel Crawford, if you can tell him to get in Zoom, because we have Brian Bruder here for a
Brian Bruder.
sentencing.
You want Gwen to go to Crawford?
No, I'm looking for that curtain. It's not.
Yeah.
And then
Yeah.
Dave's gonna get the other, right?
Actually, you can give both to Gabe. Yes, all right. Okay,
All right.
stay seated, I'll be out. What case are you here, Ron? Okay,
Excellent. Thank you.
thank you.
Good day.
Address Travell, Kimbrough, 03W46867. Did you have a lawyer today?
I got to see him out in the hallway.
I'm sorry?
What did the trial gave me?
I don't know, did we give you a lawyer?
Yes, sir.
Your lawyer's out in the hallway? Okay, I can't call this now. Dustin Hull, we'll get him in here, okay? Dustin Lee Hull, 25W837511A. B. C. And 25W837744. Come up to the podium, please. Name?
Doesn't matter.
You were charged with resisting obstructing officer. Possession of drug paraphernalia. No drug, no insurance. You also have an anti-blight misdemeanor. You have the right to a lawyer. I'll be glad to give you one at public expense if you want one. Do you want one?
Yes, sir.
You can go right out in the hallway. We'll set you up with a lawyer and then they'll come back in there. Okay?
Thank you.
Mohammed Monat.
Stephen Mammon on behalf of the defense.
Monat, 25W837795, your name?
Stephen Mammon on behalf of the defendant, Your Honor.
So we got a default that was entered. What's going on? You guys can't resolve this?
We can. I mean, I would just. I just want a 1 week adjournment on it. That's it. I need to just discuss it with my client a little bit longer.
Well, yeah. I mean, the case has been, I don't wanna. It's just obstructed vision. You can't just get a hold of them now. I'll let you check back in an hour if you want, 45 minutes.
Okay, that's fine. We can do
Either
that.
that or I'll just set it for a formal hearing for next week.
Either's fine, Your Honor. Honestly, either's fine.
What, didn't he offer you anything?
Yeah, you did. I'll check back in an hour. Okay, I'll do that. That's fine.
Okay, all right, good enough. Thanks.
Sign back in by 11:30.
Yeah, but talk to your client and the earlier the better, and you can go talk to Mr. Urick on Zoom.
Okay, thank
and
you, Your Honor.
Hopefully he'll bring the file in, okay?
Okay, thank you, Your Honor.
Mr. Crawford, what case do you have? I need the Bruder file. I don't have the Bruder file. I don't
Yeah, I have the
anything.
Bruder file. I'll be in with it in a moment.
File is here.
Per double.
Give me that. I need these files, Mr. Crawford. I don't have any files in here. I
I'm
got
on my way in with Bruder now.
one with the interpreter too, that I gotta get him out of here. We're paying him money, and your client or whoever that was, it's not been, he did not show up, of course, probably still sleeping. I don't know.
See you
So
shortly.
I need both those files, please.
Good morning, Your Honor.
Good morning, Deputy. How are you?
Very well, sir. I got Amanda Emerson here present. Then you're gonna have an Aaron Griggs, an arraignment on a warrant.
Okay, great.
Aaron Griggs, but I got Miss Emerson here now.
All right, thank you. I'm gonna do Ms. Bruder. We're gonna get Miss Emerson. Mr. Carmen should have had that. Where's Johnny? Mr. Crawford, I need the files, please. Come on. You got Amanda Emerson and Tony Carmen.
I don't know what's going on with her. He went and see Amy at the hotel.
File for anyone that needs an interpreter. I only have Mr. Bruder.
That was, Emerson was given to Tony Herman. You told me.
Hang on, let's slow down. This interpreter in the back, what case are you here on again?
Rodolfo Perdón.
He is not checked in. He's a 9:30.
Well, we're gonna issue a warrant. I mean, I wait till 4 o'clock for somebody to show up. It's ridiculous. I'm gonna get this poor gentleman out of here right now. I want. Wait 1 second, Mr. Crawford. Be right to you. Bishop. Last showing out.
Did we check the hallway just to be sure?
I wasn't, the hallway is.
Somebody call this person, you call this person's name.
Yes.
Rodolfo Antonio Perdomo, 34836-762 A, B, and C. Your name?
Come on, now we can.
So this guy appeared at 11 o'clock on the day he was supposed to be here. Back on March 19th. I don't know why I was good with setups. Court fines done at engaging in local intent to delay adjudication. Bench warrant issue. Schedule this and schedule this and schedule this, 7,510%. 7,510%, make a note that the interpreter was here. And 10% on the other five. Default judgment on this one was already entered. So if we didn't stay with the default judgment, Lisa, I want you to, I think that probably was still in effect, but if not, we're ending that now. Submit your bill. I'm really sorry we dragged you here. This is the second time that this, I hope he doesn't want me, if he doesn't, a lot of money. Brian Bruder. Brian Emmerich Bruder, thank you very much. Brian Emmerich Bruder, 248-834-255, counsel, your appearance. Douglas, your name, Mr. Bruder?
Brian Emmerich Bruder.
Pled to attempted possession of drug paraphernalia. It's got quite a record. Do you have a chance to review the report from other material additions, corrections, or deletions?
No, you want, I have had the opportunity. He asked that the court accept his recommendation. My client believes it's reasonable and fair that we can comply with.
Boy, you gotta get your life together, Mr. Bruder. Anything you'd like to say?
I'm down here getting my life together now, sir.
I hope so.
Yes, sir.
200 fines, 400 costs, 75 victim charge, $50 justice assessment. 7 1/4, 75 hours of community service. You have to complete that in this case by June the 7th. You have to submit proof of that by June the 7th, or you have to serve 45 days jail. So 75 hours of community service, 7 1/4 in fines. And your community service has to be done by June 7th, or you have to serve 45 days jail. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. You understand that?
Yes, sir.
Can you
Yes,
pick
sir.
all this? Can you pick all this
I'm
today?
discussing this with my client. He can't pay this all day. He's only started working 5 weeks ago. He works at the Southeast Kentucky Rehabilitation Industries. He's full-time, but he only makes $9.50 an hour. What he proposes is that he can pay $100 today, and he's open to be able to pay $50 every 2 weeks starting April the 25th.
Pay $100 now today, $50 bi-weekly, beginning April 25th. Okay?
Yes,
Now
sir.
listen very carefully. If you don't have the money, no problem. Call the court. We'll go on Zoom. As long as you do it on or before the due date, I don't care how many times we have to do that. I'll give you all the extensions you need, okay?
Thanks, sir.
Well, thank you very much. Get going on your community service. Write this phone number down, 734.
734.
754-671-0201,
Uh-huh, okay.
extension 245. That's the probation department. So you'll call there if you have any issues or questions, okay?
Okay, how do I pay online for,
33court.com. There is a little bit of a fee if you're not paying it in full, but that's it, okay? Good luck.
thank you, sir.
Amanda Christine Emerson, 24B145478. Carmen,
Michael A. Carmen, he's 732-4, I'm happy to defend it.
ma'am, your name? You have to unmute that if you can, please.
Amanda Christine Emerson.
Sir, I didn't know she was on Zoom. Can you please recall the matter so I can get on Zoom and talk?
Oh,
I'm sorry, my mistake.
sorry. Yeah, we'll pass the case. Yeah. Go from there.
Sorry.
It's all right. Did you have fields too?
Yes, sir.
I think I want you to take first because
Sure.
we got the. Yeah, he needs. Yes. I'm sorry. See it all come out as soon as it's something.
I can pay $100 bi-weekly.
Anybody force you to plead guilty?
No.
Please accept it. What do you think that I'm thinking? Let me let your lawyer speak. Ms. Wiles, first your name.
Elizabeth Watts, Commissioner.
Figure out while he's talking how many days credit she has. Anything you'd like to say, Mr. Garland?
Your Honor, just that my client was recently ordered to go inpatient by the 23rd District Court on a different matter. She has not been able to work in a year, taking care of her mother who recently passed away. She's been in custody for a week, and she was in the hospital for a couple days, that for a potential stroke. She is, when she's released, she can then get some funds and make $100 bi-weekly payments. And that's what we're asking for this time.
You didn't show up on this case when you were supposed to be here May 22nd of 24, June 13 of 24, August 28 of 24. You didn't show up January 6th of 25. You came in here in my absence. A visiting judge gave you a personal bond because you were testifying on another case. You didn't bother showing up again on March 19th. You run out of chances with me, Ms. Emerson. I don't know what more I can do with you. I've tried. I don't know why you are insisting on destroying your life. I mean, you are going way out there. You're gonna make sure you destroy it. I don't have anything else. How many days credit do you have?
I don't have any, Your Honor, outside of what you initially ordered. You ordered 30 days jail, and you credited her, having her serve 17 more. So from the looks of it, and in my eyes, it looks like it's 30 days, Judge.
I just don't understand. I really don't. I don't understand it. Got it, Scott. Is there anything you'd like to say, ma'am?
like, I realize the decisions I've made, the repercussions, the waves have not only negatively affected me, but other people that I care about. And, I just would like to make a change.
Probation's revoked, your pay cost of 910 is for 90 days credit 30. For a total of 60. If you pay 910, I will suspend. She do everything else she's supposed to do on probation.
She didn't have any real terms as far
I'll
as,
suspend 60 of the 60-day jail term. And you won't have to serve any time in jail. So if you pay your 910 today, we're done with this case. If you don't, you're in custody for 60 more days.
Okay. Thank you.
thank you, Chuck.
You gotta grow up.
I know.
I just don't know what to do with you anymore. Derek Latrent, Junior, 23W32779.
Judge, Amanda
Yeah.
Emerson has multiple cases.
In front of me?
Yeah, she has 3 pre-trials. It's on the
Julie,
docket.
I don't believe the trespassing tickets.
I'm gonna let Mr. Carmen talk to you again, okay? While I want to leave on her case, or after I finish this case. So just tell him we handled one, you gotta talk to him about other. Prosecutors should have the pre-trials, gentlemen. Derek Latrent Fields Junior, 23W8327779. A and B, then you also have 25W83751, A and B.
Here.
Mr. Carmen?
Mike Lake Farm, P7382 half percent.
So as I understand it, it's going to plead guilty on 510A. And then, on this 2023 case, she's moving to dismiss. Is that what you're saying? Call her in here. He's owed money 2 years. I'm not.
Is that the Brownstown prosecutor?
Go ahead, one Higgins prosecutor, that's right. Yeah, I mean, he's owed us money for 2 years on this. I mean, I'm not dismissing this case.
Are you talking about the no proof of insurance?
Yeah, I mean. Yeah, I'm not doing it.
Judge,
It's beyond the pale.
judge needs you. Yeah.
And if you guys want to negotiate something else on the suspend, that's fine. If right now I have 8375 mile away, they're supposed to be guilty on. I have 23W8327779B that is supposed to be dismissed. And where is Mr. Urick? Urick, your name?
Good morning, Your Honor. May it please the court, William York on behalf of the city of Woodhaven.
I don't want to dismiss 2-year-olds civil infractions, you know what I'm saying? I really don't. This is, you got a no proof of insurance you want me to dismiss, and the case was started back in 2023. I mean, he's been in default.
Unless I mistook it, Your Honor, I bought the new NPO line, not the show cause, but there was a new no proof of insurance on the 25.
You know what? I'm gonna stand corrected on this. My mistake. My mistake. You're right. So the intent was to dismiss the no insurance.
Affirmative.
From that, but defense state, okay. I can live with that. So, Mr. Fields, if you plead guilty on 510A, that's the driving on a suspend. I'm gonna dismiss the 510B. I'm going to dismiss then the 832779B, which is suspend, and then you're gonna deal with sentencing on 5108, that's the suspend and sentencing on the no insurance if you choose to plead guilty to failure to pay. You understand all that?
Yeah. Yes, Your Honor. Can you give me a second?
Sorry about that, Mr. Hurt, my mistake.
Your Honor, we're all here, pulling on the same warrant, each and every one of us. Thank you, Judge.
Yes, sir, already.
Cool. So you understand what I just said?
Yes, sir.
So you plead on one drive while suspended. I'm gonna dismiss the no insurance, that's for the March 22nd incident date this year. And then I'm gonna dismiss the suspend from 2023, but just have no proof of insurance contempt charge. Do you understand?
Yes, sir.
You plead guilty on the suspend from March 22nd of 25, possible penalties are up to 500 fines. 93 days jail costs for all those 2 points. Again, then I'll dismiss that, no proof, same incident, do you understand that?
Yes, sir.
And did you sign, read, and understand it, advice and rights form here today?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial of any kind, you understand that?
Yes, sir.
Okay, to the charge driving unsuspended, how do you plead?
I plead guilty.
On the 22nd of March of 25 at 11:12 p.m., were you operating a motor vehicle on Allen and Western Wooded?
Yes, I was.
Was your license suspended?
Yes,
Are
sir.
you on probation or parole?
No,
Anybody force you to plead guilty?
no.
I'll accept that plea, dismiss that no insurance charge. March 22nd date, I want to dismiss pursuant to agreement, the 23 charge for suspend. And we have a no proof of insurance you went in default on. Counsel, I can do one or two things. You can either tell me who's gonna pay this one right now, which will be in the neighborhood of about. Oh, boy. $325 or so. And then I can sentence them on the suspend, or if you want to go through the formal process in the no insurance.
Your Honor, he can pay in full on both matters today.
Okay. So on the no insurance, I'll tell you what I'll do. Are you learning anything?
Yes, sir. That's why I'm here.
I'll reduce these fines. Lisa, what is the old excluding the clearance fee?
On the insurance,
Yeah. 27798.
let me check. 297.
Thank you. Anything else that you want to say before I start some?
Just, immediate sentence, fines and costs, and then we paid, full today with the help of, Mr. Fields' father.
All right. Feels anything?
No, Your Honor.
You work?
This is what's holding me back from getting my offer of position.
Where?
Serve electrician apprenticeship.
All right. Good enough. You gotta work. All right? Stop doing this to yourself. Anything else that you want to tell me?
This license is the only thing that's holding me back from pursuing my career going further.
On the suspend charge, 100 fines, warrant costs, 75 victims' rights fee, $50 justice investment, 4 1/4, 493 days. You owe whatever, I'm gonna say, you pay 275, I'll waive the balance, and you still have to pay the claimant's fee, okay?
Okay.
On the insurance, so you're gonna owe 45 plus 270, which is 320, plus 425, which is 745. You have all that, Dad?
We'll make it happen, man.
You have it, I don't wanna make you nutty.
I mean, my goal is to help him get himself together so he can take care of his daughter. I'll make it happen, son.
All right, good luck, stop doing this, Mr. Fields. Okay?
Judge, did you address the third case?
I just didn't show.
Third case.
I have a A and a B for the,
7798?
and then there's a 779B.
Yeah, I'm just missing that pursuant to the agreement, that's part of the plea, that the B file be dismissed. Yeah, the B
No.
file is The B file is being oh, wait a second,
779B is a contempt.
wait a second, 1 second. Yes. What?
That's what I was talking.
Yeah. You already pled on this. You guys got a mess going on here. I mean, he's got a suspend charge that the conviction was entered 7 months ago, and now he wants me to dismiss it.
I'll have to relook the file, Your Honor.
Call him, Mr. Urick. Yeah, I'm gonna be fine with taking it off of there, since Mr. Ford seems to be slightly growing up, if he wants me to. I can set aside the conviction. I really hate to play that game, or do that 7 months later. But if Mr. Fields here is gonna be growing up a little bit, you are trying to grow up, right?
Yes, I am.
Well, you're 27. So Mr. Urick making his way back in.
I hope so.
Mr. Urick, your name again?
Again, for the record, Your Honor, William Eric, I may have the city.
That's what confused me, this, in part, 779B, you've got me dismissing, that's a suspend from July of 23. But he already pled to allowing unlicensed driver to drive on that, September 4th, 24.
Was not aware of that, Your
All
Honor.
right,
I
that's fine.
apologize.
Listen, if you want to set aside the conviction, we will take it off as abstract, and I will still dismiss if that's what you want to do. Is that what you want to do?
We would so move.
Okay, so Lisa, that's what I'm gonna do. Conviction set aside. Case dismissed.
Thank you, Your Honor.
I'll just make a note, prosecutor so stated. Gotta grow up, Mr. Fields, okay?
Thank you, Your Honor.
Thank you very much. So I'll set aside that conviction and dismiss that case. Good luck.
Thanks, Your Honor.
Thank you, man. Thank you. Which one's this? When? Ty, why don't you talk to Ms. Emerson again?
Your Honor, I was gonna ask if Mr. Gabe could do that, because I have arraignments in the other courtroom.
Oh, you do?
Yeah, I just have this one judge, and then I can take care of this thing.
Just want to get that lady out of here. 19 W 83661.
Good morning, Judge. Nice to meet you. Karen Bennett.
All right. Why is this smart? Why is it a no contest?
Civil liability there.
The property was recovering. Property. There's no restitution to begin with, and on a theft case, don't ever ask me to take them under no contest. That they're gonna entitle the restitution.
Please. Did you want me to have it rewritten?
No, I'll just take a guilty plea if she wants to do that. Your name again?
Tên là gì? Me?
Yes,
That Kim Hao Oprah, Your Honor.
you are still under oath.
Yes, Your Honor.
Ask her to state her name.
Tên của mình là gì? My name is Tien. Tien.
I have a stipulated plea form here
Đó, tôi có một cái
that tells me she's going to plead no contest.
chị nói rằng đó.
I'm not gonna take a no contest plea. I'm gonna take a guilty plea. If she pleads guilty, if you plead guilty, ma'am, I'm gonna take this under a statute. I'm gonna place you on probation. I'm gonna set terms and conditions. And if you're compliant at the end of 12 months, I'm gonna dismiss that case. You understand that? You understand that?
Yes, Your Honor.
For purposes of arraignment,
What's that in favor, Judge?
I'll let her not guilty plea for purposes of arraignment. If you plead guilty here, Possible penalties to retail fraud up to 500 fines, 90 days jail and probation. Costs for all of those. Do you understand that?
Yes, Your Honor.
Did you read her this advice of rights form?
I did, Your Honor.
Did the interpreter read you the advice of rights?
Yeah, yeah. Yes.
Did you understand all those rights?
Okay, but then. Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights,
Anh muốn bọn mình chấp nhận tội thì có thể không phải
and there will be no hearing or trial.
không, nhưng mà không phải ra tòa vì tất cả những
Do you understand that?
bạn là xứng tỏ. Yes, Your Honor.
All right. Okay. Do you have any questions for me before I ask you how you plead?
Cho thẩm phán không trước khi mà họ tuyên án. Có câu hỏi cho thẩm phán hay không? Vâng, thì có sẽ hỏi là giờ có không kháng nghị gì thì là giống như là người được xưng rồi.
I just asked if you have any questions. Do you have any questions?
Không phải là có câu hỏi không? No, Your Honor.
Okay. To the charge of retail fraud, let me wish to plead.
Thế thì nói làm sao?
Need probation on that. I mean, yeah, probation.
Guilty, Your Honor.
Were you in Woodhaven at 23555 Allen Road on March 5 of 25 at 7:30 p.m.?
Yes.
Did you take property without paying for it?
Yes, I forgot.
Is it true that you intentionally failed to scan certain items?
Yes, Your Honor.
Anybody force you to plead guilty?
Thế thì có ai bắt buộc mình phải chấp nhận tội này hay không? Phải bắt buộc không? No, Your Honor.
I'm gonna accept your plea. I'll take it under section 771.1 for 12 months. Okay?
Yes, Your Honor.
I'm prepared to sentence. Is there anything that you would like to say?
Judge, that this is Mrs. Nguyen's first offense. She's a new mother, she does have a newborn. But she understands that she made a mistake and this is gonna be a one-up and she's assured me that this won't happen again, Judge. So we ask the court to take those facts into consideration.
Ma'am, anything you would like to say?
I'm sorry, Your Honor.
12 months probation. I'll take the case under section 771.1. You cannot leave the state without the consent of the court. You cannot violate any law. You must appear in court as directed. When you are not to enter or go near 23555 Allen Road in Woodhaven or any other Target store.
Yes.
I'm gonna cut the probation fees to $150. 240. Pay fines $100. Cost $25. $75 victims' rights fee, $50 justice assessment. So fines and costs are $275. I'm sorry, $250. Probation fees are $150. And I'm gonna order that you pay interpreter fees of $100. So your total here amounts to $500. You serve 5 hours of community service by June 1. 5 hours, just 5 hours, not 5 days. Stay out of trouble. We will give you a review hearing fee. You come back at that time and the case will be dismissed. One other thing. You have to go over to the Woodhaven Police Department by 2 p.m. By 2 p.m. I've got that in the probation order and on an order for Chris. Lieutenant, your name?
Lieutenant Toller, what do you know?
I don't want to make the interpreter go over there and tell her this. So can you let them know they're gonna have a Vietnamese speaking individual come over there and they're not gonna be able to communicate. But we're gonna give everybody the order, tell her that,
Yes, Your Honor.
and we'll go from there. I'm gonna ask the interpreter to stay here while probation instructs her. Gentlemen, tell them I would like them to get her out of here as soon as possible. She should be first because the interpreters.
Do you want a review date?
Yeah, I'm sorry. Thank you. What's the review hearing date?
April 1st of 26 at 9 o'clock.
April 1st of 26 at 9 o'clock is your review hearing date. Put it in the calendar and show up that day and I'll dismiss your case. Okay? Can she pay all of this today? How much can you pay today?
Can I tell you half of it?
Yeah, $250 now. And I'll just give you until May 15th to pay the rest. If you violate, you could get 90 days jail. If you're compliant, this case will be dismissed. The conviction's entering now, but it will be dismissed. You understand all that?
Yes, Your Honor.
All right, I wish you well. Good luck to you. Thank you. Make sure you go to Woodhaven to get printed and photographed.
Once you're not, we'll be with you.
They're what?
Yeah. Thank you.
Ambrose, Derek Stevenson Ambrose. 258-6173. What are we doing on this?
He lives
Just
out of state, Judge, so this is the arraignment.
Is Derek Ambrose, I'm sorry.
He's on
up-
Zoom.
Somebody wrote warrant denied evidence.
That might have come from the police department. They'll have to look at that. But he's on Zoom because he lives out of state.
And so you're here. Mr. Ambrose, your name? I need you, Mr. Urick, again, please.
Absolutely, Judge.
Thank you. Mr. Ambrose, your name? Oh, he's still connected. Mr. Ambrose, can you hear me?
Yes, Your Honor, I can hear you.
Good morning, your name?
Good morning, my name's Derek Ambrose.
So, Mr. Urick, your name?
William Urick on behalf of the people of the city of Woodhaven, Your Honor.
this was a charge of improper possession of firearm and vehicle. Somebody wrote warrant denied, dated it today at 10 or something. I don't know. Will you look at this? It
Absolutely.
looks like it's Lisa's writing, so somebody must have told her that from the police department.
Judge,
Mr. Ambrose, just, what's that, Lisa?
They submitted a ticket, and then after that, they sent us that saying that the warrant was denied. So we
So-
already have the ticket in the system.
So we had entered the citation, but then the warrant was denied. So if you still want to do that, just write up the dismissal and I'll get Mr. Ambrose out of here.
Absolutely, Your
You in
Honor.
hot, Eric, you in hot Arizona, Mr. Ambrose?
I'm sorry, Your Honor.
You're in warm in Arizona.
Yes, Your Honor.
What's the temperature there?
Very, very, very hot and dry.
Is it very hot? How hot is it today?
Probably close to 100 degrees.
Already in April? Jeez.
Yes, already.
Wow. Look. Well, heavy driving in up northern Michigan. All right, we'll be right with you. Just mute yourself and we'll see what we can do here, okay? Thanks.
Yes, Your Honor.
Do another one for me.
I've got two I sent it for you.
Okay, thank you. People against Romero. Ramiro, Francisco, Romero, 25-W838-1388 and B, and I also have 1.5-23099, 8 A, B, and C. Your name?
Ramiro Romero. Good morning again, Judge.
Good morning to you.
Michael Crawford.
All right, what are we doing on these?
Well, Your Honor, on the matters, they're up for today, Woodhaven matters, there is a deal that has been presented. My client, for arraignment's sake, he has already been arraigned on his stance, wait formally on charges. He'd like to bail himself of the offer, we're about to plead to no ops. And the other two charges will be dismissed as to the flatback matters. So
That's the expired plate.
yes,
That's there's only two charges on it. So the spend will be dismissed, expired plate dismissed.
correct.
He's insurance for you and any kids that are old enough to drive. And your wife. Anything else that's ready that I can call? Jen,
No, not at the moment, unless I have a pretrial that both parties are here, but they have not spoken yet. It's on Schwab versus St. John.
all right. Let me do this. What's your name, sir?
Robert Burton.
Okay.
That's one of Mr. Nate's 9 o'clock pretrials. I didn't realize he was in person.
All right. Oh, so it's a 9 o'clock pretrial with Mr. Nate?
Correct.
And the name of that case is what?
LVNV funding versus Robert Burton.
Do you have that one?
Should we play?
LVNV versus Burton. Robert Burton, 2501460. Good morning, Mr. Burton. Your name?
Robert Burton.
Counsel?
Preston Nate, 277-884, appearing for LVNV.
Did you two talk on this? It's a small amount, $923 and some odd cents.
No, I haven't. Yeah, we haven't talked, but I believe Mr. Burton, and he might be able to give you a better update. Are you filing for bankruptcy?
Yes.
In the process of doing that?
Yes, I started the process. My mother passed away last Friday.
I'm sorry
I was in
about
the middle
that.
of the process doing it anyway, trying to catch up.
Okay, so I don't think we necessarily need to talk. Sounds like you probably just need some more time to get that all taken care of and.
You're gonna file, I mean, how long do I need to give you? I mean, if you retained a lawyer at least?
I started the process yesterday, sent all my paperwork in. I got.
You have a lawyer?
Yes, sir.
Okay, good enough. Let's adjourn this 2 weeks, Jennifer.
That will be the 12th of August. And we'll do 10 o'clock.
At 10 o'clock, okay? So make sure your bankruptcy lawyer notifies us when he or she is filed, okay? Otherwise, you have to be back here August the 12th
Yes, sir.
at 10 a.m., okay? Best of luck.
Thanks.
All right, let's go on that. Mr. Nate, do you have anything else?
I do have one other one, and opposing counsel Jennifer Palin just logged in, so we can probably call that.
What case is that?
That's LVNV versus Ronnie Jackson.
Do you have it? And then, Mr. Bard, I'm going to ask you if you have anything ready here. LVNV versus Ronnie Jackson, 2501477. Good morning.
Good morning, Preston Nate, P77884, appearing for LVNV.
Good morning, Your Honor. Jennifer Palin, P8284 on behalf of defendant.
All right, let me see here. 80284. All right. What kind of case is this? Straight collection, right?
Just a collections case, and similar to the previous one. We're just going to need some scheduling dates today, and we'll figure it out. But
Good enough. What did I give you on the other one? I'm going to mirror that. I think I gave you until September 15th to conduct discovery, no ADR. Witness list due on September 1. Nobody demanded a jury trial. There's not going to be any mediation, no settlement conference. I'm putting down 1/2 hour. Jennifer, we're going to give them the same date that I
November
gave
3rd.
on the other one. You don't have to file a trial brief. All motions for summary have to be filed and heard not later than 20 days before the trial date. What'd you give me on the other one? November
3rd.
We're going to set this November 3rd at 8:30. Ms. Palin, anything else?
Nope, that works. Thank you, Your Honor.
Have a great day. Mr. Nate, anything else?
I think that's it for me, Your Honor. Thank you.
Thank you very much. Mr. Barta, do you have any other cases down there where the other side's here and I can get you out of here?
His next one, I think, is at 9:30, Your Honor. So we're still waiting.
All right. Okay. Let's go on. Is anybody here on Discover Bank versus Harmon? They should be here on that.
Good morning, Your Honor. Yes, we are. I think she's still in the breakout room. Oh, there
Nope, she just came out.
All right. Good morning.
Morning,
Okay.
Your Honor.
So I have your appearance, Ms. Palmer.
Yes, Tiffany Palmer on behalf of Discover, P number 74809 for the record.
Okay. Give me 1 second here. And then, Ms. Your appearance, please.
Sure. Jocelyn Oy, P64890 for defendant.
All right. All these IP numbers. Okay. No resolution, right?
Actually, we do. We have both signed a proposed consent judgment and it was e-filed this morning. So the court probably does not have it yet, but we did e-file it.
Any need for me to put the terms on the record or not?
I'll defer to sister counsel. Do you want to, or since we've already e-filed it?
I don't think it's necessary.
I don't either. Thank you very much, the two of you. Have a great day.
You too, Your Honor. Take care.
Thank you. Thanks. Do I have anything else ready before I go on to this 9 o'clock motion?
We
Mr.
have a pretrial for Mr. Schwab in St. John.
Who's that? Pardon me?
Oh, right here. There's this one, and then there's that one, and then also this one. There's LVNV, which is called.
Paul Schwab versus Arena St. John. And then Mr. Schwab is a counter defendant. The defendant has instituted a counterclaim, it appears. Mr. Schwab, your name?
Paul Schwab, improper. Your Honor, I am not aware of a counter complaint. Unless I've overlooked something.
Let me see here. I didn't see it. I will look for it, but it says on the caption that they set up, counter complaint. Do you have one, Jen? I see the complaint. I see a counter complaint for money damages. Did you, ma'am, your name?
My name is Irina St. John.
Did you serve the counterclaim on him?
Yes.
How did you serve the counterclaim on him?
We send this, we submit this through the e-filing.
So you sent it to the court. Did you send it to Mr. Schwab?
Yes, I
How
did.
did you send it to Mr. Schwab?
E-filing through the electronic system.
What
Through
date?
the court, through the electronic system, through the court.
I know, ma'am, listen to me. Jennifer, do we have any evidence that she served this on him?
I'm showing that on June 5th, it was filed and emailed to pschwab@attorneyschwab.com at 6/5 at 3:57 p.m. But I don't see where it was opened or by Mr. Schwab's office. Because I can see when it's opened and downloaded, and I do not see that it was ever opened.
So if you guys think you can go into a breakout room and try to discuss this and resolve it, or would you rather I just go ahead and set dates?
I believe we're going to have to set dates. Miss St. John is just insistent.
Okay.
She's done more than this. So she's filed a grievance also. So she's very adamant that I'm a bad attorney.
Or we can discuss now. It's up to you, Your Honor.
Well, I can't force anybody to settle.
Yes, I understand. We can set up the dates.
You know,
and I'm going to be the fact finder here. Nobody demanded a jury trial, right?
Right. Correct.
I'm going to be the fact finder, ma'am. I can't force you to settle, and I shouldn't be involved in settlement negotiations since I'm going to be the one to determine whether or not either party or one of you are entitled to monetary damages against the other. So I'm just going to go ahead and set dates.
Well, Your Honor, if I could interject, this is the first time I've heard Miss St. John say, well, maybe we can't talk. So maybe a breakout room would be.
Yeah, we'll put you in a breakout. This one's going to take a while that I'm going to start on this motion. So,
well, let me do this. Let's get the dates, and then I will contact Miss St. John, or if she wants me to do something else. But yes, let's do that. Miss John and I will continue, but we'll have dates for a trial. That would be helpful.
Okay, so let's do this. First of all, counsel, am I correct? Did I not see in here that you're only asking for 1627, right?
That's correct.
And what are you asking for, Ms. St. John?
I'm asking for not to pay remaining balance 1627 and return $10,000 that I already paid to Mr. Schwab, and money for imposed appraisals, which is $3,570.
Let me ask you a question. Is the divorce resolved?
No.
Did you terminate Mr. Schwab, or did he withdraw before the end of the divorce?
I terminated Mr. Schwab due to the lack of action in my divorce case, which was stagnated and delayed.
Sometimes the judges do that though, ma'am. You know, they got backed up, I think, a lot over COVID. I could be wrong. I'm not speaking for them. I don't know what they did or didn't do, but let me do this. I'm going to just go ahead and give you guys, I'm not going to order ADR. We're going to give them a little bit of discovery, Jen. I'm going to give you until, do you guys want discovery?
I don't need it, Your Honor.
Ma'am, do you want any discovery here? where you can, discovery is the exchange of information.
No,
And
I
by
don't
the
need-
way, I'm just telling you, I'm not trying to give you a hard time. I want to make sure you understand something. I don't know why he wouldn't have, there's only two ways he doesn't have to pay these fees. I'm sorry, only two ways that he would be responsible for returning the fees. One, it was either malpractice, or two, he overcharged you. You're going to need somebody to help you, ma'am. I mean, I know there's this trend now where people are going on the computer and pulling up documents and that they can use, but you still need to prove your case on your counterclaim, and there's only one of two ways to do that. I just want to caution you. I'm going to give you guys until, let's see, today's the 29th. I'm going to give you until November the 1st to conduct discovery. And that's the exchange of information. Nobody demanded a jury trial, correct?
Correct, Your Honor.
I'm going to have you file your witness list by October the 1st. You do have to file a trial brief. I'm going to make you guys are going to have to file a trial brief and exchange it no later than 7 days before the trial date. I'm not ordering ADR. We're going to give you a date. All motions for summary have to be filed and heard not later than 20 days before the trial date. Lisa, Jennifer, why don't we give them late November, okay?
Okay, Judge. That will be November 17th at 10:30.
At 10:30. November 17th at 10:30 will be the trial date. And I'm going to put down 2 hours for this one, okay?
And Your Honor,
I'd encourage you to talk, ma'am, to Mr. Schwab and see if you can't resolve it. I don't know what kind of work he did or didn't do on the claim, but I don't know what the hourly rate was, but $10,000, I don't know where you went. So I'm just going to encourage you to speak to him. And by the way, counsel, I'm going to have to, on the further orders, plaintiff/counter defendant shall file an answer to counterclaim and affirmative defenses on or before. We won't get this out, so I'm going to go ahead and just say, let's see, 29th. I'm just going to say August the 23rd. Okay?
That's the answer to the counter complaint.
Correct.
Correct. Your Honor, it will be filed long before that. Now, the trial, is that in person or by Zoom?
Yeah, we're going to have to do this in person.
Okay.
All trials I do in person.
And I will make one other comment. You commented on the high bar number. Mine is a very low bar number.
What is your number?
20120.
Now, were you on the initial group where they just alphabetized?
Yes. Oh, yes.
What? So you've been practicing since what year?
72.
Wow.
Yeah, I was there before they had bar numbers.
Have a good day.
I just thought it was funny because
I know. Well, I get these 85, 87, and it's like, wow.
Yeah, they're young.
Old.
They're young.
Ms. St. John, do you have any questions, ma'am?
I don't have any questions.
Okay. All right. I wish you guys well. I hope you'll speak. Thank you very much.
Thank you, Your Honor.
Thank you.
Thank you.
Okay.
Goodbye.
Bye now. Let's take LVNV versus Collins, Christopher Collins, 2502125.
Ryan Moali, P88457, representing LVNV funding.
The defendant's not here, is he, Jen?
No, Your Honor, I've not had the defendant check in.
Counsel, I'll give you a default. You're just going to go ahead and give me the breakdown, if you would, please.
Yes. Defendant owes the amount paid for in the complaint, which is $490.96, a filing fee of $36.05, service fee of $39.16, statutory attorney fee of $75 for a grand total of $641.17.
You could submit your default. Default is granted. Defendant was to be here at 9, did not show. It is now 9:17. I gave him 15 minutes. So you can go ahead and submit your default. Thank you.
All right, thanks, Your Honor.
All right, now, okay. This one's gonna take some time, so if I have anything else, if anything else is ready, I would like whoever has it to tell me. If you have another case, even if it's at 9:30, if both parties are here, I will call that now. Anybody? Ms. Palmer, what cases are you here on now?
Yes, Your Honor. I have a 9:30. It's Capital One versus Bosquet, but I don't see anybody that has the.
Is that defendant here?
No, Your Honor.
All right, I'm just going to go on to this case. This is called Matthew Haroni versus Adam Randall, DBA Tilchin and Hall PC, 2501675 RGC. All right, Mr. Haroni, your name?
Good morning, Matthew Haroni in pro per.
Ms. Ford?
Good morning, Your Honor. Corrine Ford on behalf of the defendant, Adam Randall.
So I was off yesterday and I had no idea how lengthy these motions, and I must have somewhere in the neighborhood, I don't know, could be wrong, but I gotta have 300 pages here between motions and exhibits. I'm not even sure I know where to start. I'm not sure. I'm gonna try to plow through this. But I honestly wish I would have had more time, to be honest with you. It was a lot to digest, and I did the best I could. I guess I'm going to start with your motion to strike the amended complaint. And I want to ask you, so do you want to start with that?
I think that makes sense, Your Honor.
Look, so I would agree with you from what I read. He did not file the amended complaint properly. Okay. But why not allow leave to file the amended complaint?
Well, at this point, if you're going to allow him to file leave to amend the complaint, then our motion for summary disposition is basically going to be moot.
Well, I understand that because.
So we'll have to refile that motion.
You're not telling me venue is improper here though, right?
It is. Mr. Randall does not live in Wayne County. He does not work in Wayne County.
Well, doesn't
He
he
lives
work?
and works in Oakland.
Wait a minute, doesn't he work in Wayne County if he does conduct business here? He's representing a condominium association.
He does represent a condominium association that is Wayne County, but he lives and works in Oakland County.
I know, but it's still, one of the prongs is resides or conducts business, right? Does he not conduct business in Wayne County? I mean, if you want to say, Judge, I think that the venue is proper, but for the convenience of witnesses and parties, I'm going to order that, I'm going to ask you to transfer the case. You're going to have to tell me why it's more convenient for a case to be transferred to another court when all the witnesses, if any, are here. I mean, where are all the witnesses? I mean, you can't say it's one of the prongs.
Correct.
Okay, so venue on its face is proper. The only way to do it is say for the convenience of parties and the witnesses that it's more convenient to be in another jurisdiction. So if you're going to tell me that I'm wrong, you can tell me I'm wrong. Judge, here's why I think you're wrong, and I'll be glad to listen to that. Let's start with that aspect of this.
Well, I think that is going to actually depend on if he's allowed leave to file the amended complaint. and which claims, if any, survive after we refile a motion for summary disposition. Then it may be dependent on what witnesses need to be called. Because if all of the claims are against Mr. Randall may be the only witness, other than Mr. Haroni and his wife.
Well, that may be, but look.
I mean, the venue argument goes, I mean, that's in regards to the motion for summary disposition. So if you're going, I mean, so I don't know if that even needs to be decided today.
Well, it doesn't, but you probably should have filed a motion to change venue if you were serious about it, rather than just saying venue is improper in your summary disposition motion, right?
Okay, understood.
Sir, I read some of this, and I read it, when I say I read some, I read a lot of it, but let me just pull out something here. Give me 1 minute, please. This was a lot to try to digest. What she's saying when she says you're not the real party in interest is that any of these fees, any claims under the Fair Debt Collection Practices Act must fail because you're not the one that was assessed the fines. Is that not your argument, Ms. Ford?
It is to a point, and also there were no debt collection actions taken. So at all. So, I mean, those claims don't even apply.
So you're not really the real party in interest here on most of these claims. I mean, look, you do what you want. If you want to do this, that's fine. And I'm not trying to discourage you, sir. I'm yet to see anybody do this competently. I'm yet to see any improper party, maybe one or two in my 30 years here. Now I know there's a lot of things on the internet now, and we can pull things up and read them and think we understand them, and maybe you understand them better than I think you understand them, or understand them better than almost any improper party can understand them. I don't see a real good claim here, sir, to be honest with you. From what I've read, I could start over and simply strike the amended complaint. I could do that. Because you improperly filed it. It's late. You only have 14 days. You can't just start filing complaints, amended complaints after that time period with no leave from the court. Now, I'm going to talk, and I'm going to say to you two this. Is there a way the two of you think you can be civil and go into a breakout room and talk about this or not? If you can't, I understand. It's okay. That's why I'm here.
Yes, Your Honor, I can.
I'm sorry?
Yes, Your Honor, I can.
Do you want to try, Ms. Ford? See if you can resolve it right now before everybody spends a lot of time and a lot of money. It's not, and I'm not referring to myself. I'm referring to your client and you and Mr. Haroni. And maybe there's a resolution. I don't know what it would be, but maybe you can try. I'm telling you, sir, I don't know how any of these acts constitute slander. I mean, I suppose if they're, or libel rather, I suppose if they're defamation, I suppose if there were untruths that were stated, falsehoods that were stated by a lawyer, and it harmed the reputation of somebody, on that count, you might very well be the real party in interest. But what he was doing was communicating with your spouse by letter and saying, these things can't go on, they violate the bylaws. And if, go ahead.
Respectfully, we don't agree that we ever broke any bylaws. And
I'm not saying you did. I don't know if you did or not. I mean, there's a lot of things in here about recording devices and cameras, and that would, on my reading so far, would be a violation. Look, I'm kind of rambling here. Do you two want to go into a breakout room and see if you can resolve it? If you don't, I understand.
Yes, sir.
We can, Your Honor. Just one more thing, though, before we do that, going back to the motion to strike the amended complaint, there was another part to that motion, and that was to seal Exhibit 22. That was involving the documentation that Mr. Randall submitted in response to a complaint that was filed against him by Mr. Haroni and the Attorney Grievance Commission. So that's a confidential process. So we would ask that exhibit be sealed.
And that's Exhibit 22.
Exhibit 22 to the amended complaint.
Yeah. Why don't you two, I'm going to take that up, and I tend to agree with you. I'm going to take that up. Why don't you two go into a breakout room right now and see what you can resolve, if you can resolve it. If not, come on back in. If it breaks down, I'll call your case immediately, okay?
All right. Thank you, Judge.
Thank you. I want to make sure. I want to see Exhibit 22. Tabitha. Jennifer, do you?
Yes, Judge.
Hang on. Okay. I got it. Do I have anything else ready?
Wait a second on record.
Let's do it. Is any other civil case ready, Jennifer?
And Judge, I have two parties in a breakout room on one.
Fine.
And
Okay, I'm gonna do this signing on record real quick. Donald Allen Bankovich, 25G716663. Good morning, Detective. Your name?
Morning, Aaron. Gary Robinson, Rockland Police Department.
Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God.
I do.
Okay, go ahead.
On 6/19/2025, Officer Sergeant Seifert responded to GBY Arena for a disturbance. During his investigation, he found that Donald Bankovich was attempting to load up a boat that he was purchasing. The boat was too large for the trailer, and further investigation realized that the trailer was not his. He didn't have a trailer. He grabbed a random trailer in the boatyard attempting to load on this boat that he was purchasing. He admitted to the officers that he planned on using that trailer, which was not his. He had no permission to use to transport his boat. During the incident, he did destroy the boat also, or did destroy the trailer. The trailer is no longer usable.
And what was the value of the trailer?
So I have some quotes between $6,000 and $11,000. 3 different quotes from Mr. Siminkevich. He was the owner of the trailer.
Based on your sworn testimony, I find that the crime of larceny, 1,000 or more, but less than 20,000 was committed. There's probable cause to believe the crime was committed by the defendant. You already signed the complaint. Court is signing and dating both the complaint and the warrant for the arrest of the defendant. Anything else?
Thank you, Your Honor. He's actually here for a PCC next door at 9:45.
Okay.
Can I probably have Judge Hessen arraign also?
Well, I mean, I'm supposed to arraign.
Oh, okay, yeah. I assume he's in custody here.
I don't know if he is or not. Did I set a bond on him already that he couldn't post?
Yes, it was 50,000, 10% with a tether. We called yesterday. He was still in the county. So
Yeah. So if he's here, we can get him a lawyer and I'll arraign him now.
Oh, cool.
Okay?
He's not, okay, thank you very much.
Thank you. I'm going to take a 5-minute recess and come back then, okay? Thanks.
I know, right? Thank you. Have a good one.
What's that?
I said, thank you. Have a good one.
You too. All right. So there's no opportunity, no chance of resolving this, correct?
No, it does not appear so.
All right. So what would you like me to address? Let's start with that. You want me to rule on your motion to strike the amended complaint and to seal the document pertaining to his communication with the attorney grievance?
Correct, Your Honor.
Mr. Haroni,
Yes.
do you acknowledge that you did not file, after reading their motion, your amended complaint appropriately?
Your Honor, I may have been confused, but I did file the amended complaint after I initially filed in small claims, and then when it was removed to general civil, it was within 14 days of that removal.
But you have to file within 14 days. That's not the 14 days. That was an order. That was, they're supposed to answer the complaint within 14 days. You want me to seal this record, identify the interest, counsel?
Yes, it's Exhibit 8. That is a document where Mr. Haroni had submitted a request for investigation against Defendant Randall with the Attorney Grievance Commission. That request for investigation was dismissed back in May of 2025. So attached as Exhibit 22 was Mr. Randall's response to that request for investigation. The attorney grievance process is a confidential process for reasons that the judge is probably well aware of. And so we just asked that that document that was produced in that process be sealed from public.
All right, and you received this, correct me if I'm wrong, Mr. Haroni. Did you receive this when the Grievance Commission told you they were not going to take any action against Mr. Randall?
Yes, sir.
What is the relevance of that to any claim or count that you have?
Your Honor, the statements that he made in his admissions to the AGC are full of untruths and speak specifically to my family and my children.
Okay, but what, okay. Ms. Ford, let me ask you a question. Again, I hate to keep apologizing, but I am going to apologize if I haven't already. I've read this, but geez, oh, Pete, my secretary tells me there's 400 pages here. So I did not go through this thoroughly, but do you agree that if any of these claims survive, that he could at least use the statements made to the Attorney Grievance Commission by the defendant as impeachment evidence?
No, I don't believe so. And all of the statements made in that document are taken from other documents that are already in play. I mean, that's just a recitation of the facts that occurred. So those facts are alleged in other documents. I don't think it's necessary to use what was in play with the Attorney Grievance Commission at all in this lawsuit.
Well, look, let me just see this for a second. Let me look at this for 1 minute. Give me a second.
Sure.
Is there anything in here, sir, that you would need, that you can't prove otherwise?
I could write an affidavit regarding the contents of the AGC response, but I redacted the confidential information, and those responses only contain information about this case and these facts.
All right. All right, I'm gonna strike the amended answer to the amended complaint. If you want to file an amended complaint, you have to seek leave of the court. So I agree with the defense The amended complaint is stricken from the record. In the meantime, since I'm striking that, I'm also, as of this time, ordering a sealing of the Exhibit 22, which is the response of the defendant to the Attorney Grievance Commission. That's the one you're referring to, correct, counsel?
Correct.
So the motion to strike amended complaint is granted. You're going to have to seek leave of the court. In the meantime, I am sealing Exhibit 22 as referenced in the documentation here. And if you think that that is going to be something that you need to focus on, then you can, after you seek leave and acquire leave of the court, you can ask me to unseal that. But I can't imagine me changing my mind, but I will keep an open mind on that. If you're going to seek leave, you better do it quickly.
Okay.
Now, this seems so personal to me between what's going on, what is going on here. It just seems very, 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 right now, that debt that they were attempting to collect was not against you. She's right. You're not the real party in interest. I don't know how you're going to get this to libel or slander or any kind of defamation based on anything that I read. But again, I'm telling you both, I have not read this in detail like I will before the next time. So you pursue this as you wish, but you have to have a valid claim, Mr. Haroni. Okay, otherwise you're subject to sanctions. That's all I'm going to say at this point. Prepare your order, Ms. Ford, send it over, and we'll go from there. Anything else? Any clarification that's needed, Mr. Haroni?
Not at this time.
So you're not to distribute that document. You understand that? I'm ordering that sealed. You understand that?
Yes, Your Honor, I understand.
Okay, Ms. Ford, anything else?
Just for clarification, so in regards to the motion for summary disposition, are you denying it? Are you holding it in abeyance?
I'm not going to even rule on it. I'm going to give him an opportunity to amend his complaint in fairness.
Okay, and then go from there? Okay.
Correct.
All right, understood.
Thank you very much. Have a good day.
Thank you. Have a good day.
Bye now.
Bye-bye.
Jennifer, you heard what I just said. I'm granting, will you write all this down? I mean, I got documents.
Yes, Judge, I made notes that you are
Trees.
restricting the amended complaint and sealing Exhibit 22.
Correct. And telling him he can seek leave. Well, a lot of trees were killed on this case, huh?
Yeah, 460 pages, Judge.
Is that what it is? I thought I was overestimating when I said initially 250 or 3, I think I said, and then.
Yeah, no, you weren't. You were underestimating, believe it or not.
All right. What do I have to send down? I'm going to keep the rest of this. These are all my copies. I'm sending.
You had a set, and there was a packet that I have that's bound.
Okay, thanks. All right, let me just get organized here. And then I'm going to call Michigan Legacy here momentarily. Look at this. All right. Michigan Legacy Credit Union versus Kathleen M. Kine, 19W2692GC. All right, Mr. Mull, your appearance again.
Oh, I'm sorry, Your Honor. This is Andrew Gallster on behalf of Michigan Legacy.
No, this is another Michigan Legacy case I got.
Understood.
Your appearance?
Good morning, Your Honor. Ed Mull, MAHL, P27115 for Michigan Legacy.
Ms. Kind, your name?
Kathleen Kind.
Any issues?
She did bring a lot of documents this morning. There's a couple of documents she did not bring. She made a list of those.
What are those? Documents she didn't bring?
Did you ask me what goes out?
Yeah.
W-2 forms for the last 3 years.
Income tax
2022
return.
income tax return.
Wait a minute. You guys are talking to yourselves. Talk to me. I can't hear you.
2022 tax return.
She didn't bring W-2. W-2 forms for the last 3 years, you said?
We asked for W-2 forms for the last 3 years.
And she didn't bring those?
No.
Or the 22 tax returns?
Correct. Or a deed to the real property. And that's those 3 items, I guess.
What do you want me to do?
We'd like to put this over a couple weeks in the control date. I'm sure she'll provide those to us because she has provided other documents.
Jennifer, give me 3 weeks, please. So you have to send him those. If he's satisfied, he'll cancel the creditor's exam. But don't just not show up if you send him and assume that he's satisfied. Okay, so your obligations to be here on August the what, Jen?
The 12th? Is that
That's-
enough time? 2 weeks?
Another week.
Okay, the 26th?
26th at 8:30, okay? So make sure you get him those, ma'am, all right?
All right.
Do you have any questions or you?
Can we do that by Zoom?
Yeah, I could care less. I was surprised you showed up. You guys can appear by Zoom, but you have to obviously get him the documents ahead of time, okay?
Thank you.
Thank you very much.
I have 2 Zoom matters before you this morning. Would you prefer that I stay here or that I go next door and
You
check
can,
in?
you can do whatever you want. Let me see what I got. What cases do you have?
Good luck. I've got one which is called,
Just come up and tell my recorder. I'm gonna move on here. Samsung, what do you have there? What's your name?
Right.
He's one of your 930s, Judge. He just logged
Yeah.
back in. We're good.
What's his name?
That is Mr. McCray, John McCray, City of Westland case.
Okay, LVMV versus Josie Dominic, 2403963. I'm gonna get,
that's mine, Judge.
okay, your appearance?
Good morning, Edward Mall, MAHLP 271115 for LBNB funding.
Is Josie Dominic here?
I have not had her check in, Your Honor.
Let me see. Well, it was scheduled for 9:30. You filed, actually, she filed a motion to set aside the default, right?
Well, we filed a motion to set aside the default because it was dismissed for failure to file.
Oh, I see. Yeah.
It was served, I think, 4 days before the dismissal date. It just didn't reach you in time. So, and it was served by, all.
All right.
So what we're asking is that the case be reinstated. The defendant did not file or answer.
I know, but here's how I do it. Case ordered reinstated. Plaintiff to serve defendant by first class mail at her last known address. At her last known address. A copy of the summons and complaint and the order granting reinstatement. Defendant shall have 28 days to file an answer to complaint and affirmative defenses.
All right, so we're going to give you an order of reinstatement, and then we're going to serve the defendant with a copy of that order of reinstatement and also a
Copy of the summons and complaint to a first known address, and then you'll file a proof of service saying you did so, and if she doesn't answer in 28 days, you can submit your default. Okay, so that's that on that one, and for the record, it's 9:56, and this was scheduled for 9:30. What other one do you have? What time's that at?
That was, I think that was set at 9 o'clock. It's Elza Holly Medical Consultant versus Carnita Davies.
It's at 10 o'clock, Your Honor.
Oh, it's 10 o'clock.
Okay, I'm sorry.
That's okay. City of Westland versus John McRae, 2500930.
Good morning, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
Good morning. I could not pull up this answer for some reason. I don't know why. I just couldn't get the answer of the defendant. Mr. McCray, your name?
McCray. Only got a silence.
Mr. McCray, your name?
John McCray.
Okay, so now I was able to pull it up for some reason this time. Well, what do you want to say, Mr. Cox? Did you read his answer? He's saying you guys didn't submit it.
Yeah, Judge, a couple things have been going on. This is about a $900 unpaid ambulance bill from 2023. The defendant's alleging my client didn't timely bill it. And over the course of the litigation, the time the court afforded us, he's contacted his insurance company. He's made a representation to me that they're going to pay $400, and that check was put in the mail end of June. I've been checking with my client about every 10 days, and they don't have any record of receiving $400. But I will note that the $400 is at less than half of the amount, and there's not an accompanying adjustment. So this seems to be a partial payment whereby the defendant would, in plaintiff's eyes, be responsible for the remainder. I don't know. I talked to Mr. McCray in the breakout room. Part of me is inclined to adjourn this about 30 days to see if we can get that money and negotiate on the balance. The court set the matter for trial on August the 26th. And so I don't want to run afoul of the court's order and dates, which is why we put this motion on the board to begin with. But right now there's a partial payment somewhere. We haven't tracked it down, but then there's a little bit of work to do on negotiating toward the remainder and seeing if we can resolve it. So, alternatively, Judge, the defendant did file a response to the motion, a letter or a couple sentences that basically said that very thing, that he's contacted insurance and they're making partial payment. But so I think the court's options are adjourn it or grant the motion and then wait for the money and try to collect the remainder. But we are agreeable to an adjournment. I don't know if we can use the trial date as a motion date and reschedule the trial, but that might be one pathway.
Did you submit it to your insurance carrier, Mr. McCray?
I recently contacted them as soon as all this started because I thought I got paid by them. And fortunately, I got a sympathetic ear, and that's what got me this far. I'm not quite sure where they came up with the number $400, but like I told them, I appreciate any help they could give me.
I know, but I don't know.
I did submit, and I had to fax over to my health the EMS bill that I recently received in our first date with our first date here. I did have to submit that. They needed the detailed bill before they could do anything.
I hate to tell you this, it's your responsibility to contact your insurance carrier. When you got the bill, you should have submitted to your insurance carrier. I don't know why you're blaming them.
Well, I'm not really blaming anybody.
You're the one responsible for the bill, and I know those are outrageous bills for sure. I mean, EMS services, when somebody comes, picks you up, people have a tendency to think their taxes should cover it, and I can't say I necessarily disagree with them, but that's not my call. It's not covered by your taxes, and they submitted that to you, and you had the responsibility to go ahead and submit that to your insurance carrier. And it's not fair for me to say, well, you wanted them to do it, they didn't do it, therefore they eat the money. And I don't even know if that's usually covered by insurance, to be candid with you, sir. So I'm sorry, what I'm going to do is I'm going to grant their motion for summary disposition. There's no genuine issue as to any material fact here. I'm going to give them $859 plus their filing and service fee. If the insurance company pays $400, you can deduct that from the balance. Give me your breakdown, Mr. McCray. I'm sorry, Mr. Cox.
Judge, we attached a proposed order, but we can obviously e-file that again. What we show on this is...
Wait a minute, let me check.
Oh, is this, I'm sorry, is the 33rd District Court e-filing? Yeah. We submitted it, well, I think we did.
Judge,
But-
I may have it in the pending box because the orders don't go down.
We can also resubmit it, but I will represent to the court that the principal amount is $859. We've got court costs of $104.35, which represents a $45 filing fee, a $38 service fee, a $20 motion fee, and a $1.35 e-filing fee, and a $75 statutory attorney fee for a total of $1,038.35. And that's the amount we set forth in our proposed order, and I can e-file that if some courts like that we sent the order over a second time after the motion's heard. But I think we submitted it.
Judge, I have it. I
Okay.
can send it to your signature box.
And we would request the court check the box if the judgment order resolves the last pending claim and closes the case. There's 2 boxes there. We didn't check either one, it looks to me like.
All right. So if the insurance company pays $400, that's obviously going to reduce your liability here, sir. That's all I can say. So I'm going to grant the motion. I'll look for you to send me over the order, Jennifer, or if it's not already in my inbox. And I sympathize with you, sir. There's nothing I can do. Good luck to you. Thank you.
Mr. McCray, I would still encourage you to follow up with me with regards to where your insurance company sent that check so we can track it down and give you proper credit. And then ultimately also, if you want to make an offer on what's left, they don't have to accept it, but they might if it's a lump sum. So I'd encourage you to do that as well.
Okay.
Thank you. Thank you, Judge.
All right, thank you. Capital One versus Sims. This by Licity Sims, by Licity Sims, 2501326.
Judge, that's Mr. Bardas. He's in a breakout room with one of his 10 o'clocks.
Michigan Legacy versus Tyler Ryan Hurd and Michael Wayne Howling, 2501458.
Good morning, Your Honor. This is Andrew Gallster, P52839 on behalf of Michigan Legacy Credit Union.
Yeah, I read this. Give me 1 second here. All right, is Tyler Hurd here? As I understand it,
Not had him check in.
as I understand it, you have service against Hurd. You do not have service against Howling, correct?
Correct, Your Honor. We're still attempting to serve defendant Howling.
Right, so this is just against Hurd, true?
Correct, Your Honor.
All right, and the balance owing, you told me, was 12/9/1864 in your brief. What other costs do you have?
So we have court costs of $244, which includes filing fee, a motion fee, and service fees. $20 statutory attorney fee.
$20? You mean 75?
Or 75, excuse me.
That's okay.
And the total judgment amount is $13,100. Well, I have $182.64, but we're short $55 then.
Because you didn't add that in.
Correct.
13,182.64, you said?
Correct.
So it should be 337.64, right? Is that right?
Correct. Or 237,
237.64.
Yeah.
Cool. All right, so submit your judgment. I'm going to go ahead and grant your motion for summary. He didn't file a response. He didn't show up. Motion for summary disposition granted. You make sure that when you submit your order, if you would please, that you just indicate that the case against Howling is still pending.
Okay. Your Honor, we did submit the proposed order and judgment with the motion. Or would you like us to resubmit it?
You have it, Jennifer? Oh, wait a minute. Here it is.
Oh. I'm sorry, Your Honor, and
Oh, I don't. I'm gonna need you to submit one, okay?
okay. Thank you very much, Your Honor.
And make sure you include that about the case still pending against Howling.
Howling.
Thanks.
Okay, understood. Thank you.
Capital One versus Bosquetti, 2501643.
Good morning again, Your Honor. Tiffany Palmer on behalf of plaintiff P number 74809 for the record.
Morning, Mr. Bosquetti. How are you? Your name, sir?
David Bosquet.
Good morning. I'm sorry I mispronounced your name. Give me 1 second here. I want to pull up. Your motion. Okay, so I didn't understand that. It was something to the effect misunderstood rules or something like that. And then we were scammed by Publishers Clearinghouse. Is that what you said, sir?
Yes.
How are you scammed by Publishers Clearinghouse?
Said that you had won a prize.
We won a prize.
I know, but how does that relieve you from this debt? What does that have to do with anything here? Why didn't you answer the complaint? And do you have a defense to this?
Am I allowed to help talk?
Who are you?
A friend from church.
No, I'm sorry, ma'am. I wish I could let you help.
That's okay.
But I just can't. You're not a lawyer, and I cannot allow somebody who's not a lawyer to practice law. Sir, is this your debt here?
No.
What do you mean, no? You didn't take out a credit card with Capital One? Wait a second. Let's slow down here, folks. Now, ma'am, are you Mr. Busquets' wife?
I am.
Okay, but you're not a party here. Okay? They didn't sue you. So I can't allow you to help him, talk to him, represent him. I'm going to make sure he understands everything here. All right? They think you owe them $10,180.58. Now you're in a courtroom. You can't tell me, no, that isn't my card unless that isn't your card. You can't talk. Wait a minute. Your friend can't help you. Your wife can't help you. I mean, no disrespect, sir. I'm going to make sure that you understand everything, but you cannot confer with other people here. If they were in the courtroom, I wouldn't allow them near you by the podium here. We're doing this because we're trying to be nice, and we want people to be, I guess, we want people to have more convenient access to the courts. I want you to listen to my question. I want you to not talk to your wife or your friend and answer this question. Did you take out a credit card with Capital One? Yes or no?
No, I did not.
You never used a Capital One credit card?
No, sir.
It's got your name all over these documents here. You don't have to sign a application if you get the credit card and you start to use it and you don't pay on it. then you're on the hook for the money. Do you understand what I'm saying?
Yes, sir.
Give me 1 second. I don't know what the Publishers Clearinghouse, look, you didn't answer the complaint on time, and you don't seem to have a defense. You're writing the court administrator, I see here, and you're saying, I don't know what the charges are for. I did buy, you said 3 pairs of pajamas or something like that. What'd you say here? Give me 1 second. It would have been helpful if items purchased were listed, including the date of purchase. That may help to determine if there were any fraudulent purchases. I do recall buying pajamas, 3 pairs of Dockers slacks, 2 pair of denim pants, and a light jacket. My wife and I are 83, have been scammed by Publishers Clearinghouse. We struggle to pay the debt this caused with our Social Security, with our SSA and pensions. Did you make a police report? Who scammed you? You can't just say Publishers Clearinghouse. Who scammed you, sir? Sir, are you listening? Listen to me. Who scammed you? And how did they scam you?
Publishers Clearinghouse.
I know, what'd they do? Talk to me, sir. You got to talk to me. Don't talk to your wife. Sir, you have to talk to me. Please talk to me.
I didn't have to have the money at the time, and I was a little bit late, but I did pay for it.
Pay for what?
So pajamas, I guess.
How did Publishers Clearinghouse scam you? Did you make a police report? Sir, you got to talk to me, please. I got all these people waiting. I can be patient, but I don't want to keep them waiting. Would you please talk to me and tell me how Publishers Clearinghouse scammed you, and did you make a police report? Man, sir, are you capable of driving? Do you drive a car?
Yes, sir.
Do you have a valid license?
Yes, sir.
Why don't you drive up to the courthouse? You live right half a mile, 3/4 of a mile from here. Do you mind doing that? Will you do that for me, or is that going to trouble you some way? Mr. Bosquet, you got to talk to me, sir. We got to talk. I feel like you got to help me out here. Can you drive up to the courthouse?
Yes, I did.
No, can you now drive up to the courthouse? You can't be more than 4 minutes away. You live on Jackson and Trenton still, right?
Yes, I did drive in.
who is the woman, the friend here? Listen to me. Tell me your name.
Holly Tiss.
Spell your last name.
It's Thisse. They are at my house right now. They're not at their house. They don't have internet.
Where's their house?
Their house is in Trenton,
Where's your house?
in Woodhaven.
How far are you from the courthouse?
Probably 6 minutes if I don't hit the train.
Are you just friends with them? Or are you related to one of them or not?
My husband is related to them.
How?
David's wife, Sally, and my husband's grandfather are cousins.
Okay, I need him to talk to me. He's not talking to me.
He has dementia.
Yeah, see, that's what I was worried about.
Yes.
That's why, okay, I got it.
We can drive over.
Does Mrs. It looks like he owes this debt. I'm just trying to figure out if somebody scammed him, and if they did, I want him prosecuted.
I'm beginning to think that the issue was the dementia and not the scam with this particular debt.
Yeah. All right, why don't you drive him up here? Can you do that? You got a valid license?
Yes. Yep.
Just be careful, okay, Miss Palmer? You can do what you're gonna do and then come back in 20 minutes or so, or half an hour.
Do you want me to come up there, Your Honor?
You don't have to come up here. I'm just saying you could Zoom.
Okay.
No, but I'm just trying to say you don't have to wait and listen to me go on with everything else. You can come back at 1:45, okay? Thanks. Thanks. Come on up, folks. We'll try to handle this. I'll figure it out.
Okay.
Albert Allen Wellens, 254-837-204.
Good morning.
Your name?
Albert Allen Wellens.
You have the money here?
Last time I was here, I made a payment arrangement. As soon as I made that arrangement, I lost my job. I'm back working.
Slow down a second. Did you make a payment arrangement with me?
Yes.
$40 a week starting February 14th.
I did, and I lost my job.
What did I tell you if you didn't have the money?
I don't remember.
You remember. You remember, because I tell everyone.
What did you say?
I told you if you didn't have the money to call the court, we'll go on Zoom or come up, Your Honor, before the due date. Did I say that or not?
You know what, you probably did.
I know I did, because I tell everybody that. I might miss one out of 150. So you didn't pay a nickel since, hang on a second. You didn't pay anything since February 3rd. We show caused you. You didn't show up June 26th.
I didn't.
You didn't what? You're not going to tell me you didn't get the mail.
Probably did.
You probably didn't? I didn't hear you.
I probably didn't get it.
You probably didn't get it? You assume you're not going to get it?
I never check the mail. My wife does, so I probably didn't get it. I probably didn't look. Honestly.
Where did you work at?
I was working at Manheim, but now I'm just doing roadie work.
Roadie?
Yeah.
For who?
It's an app with deliveries.
Listen, I'm going to help you here.
I know you do.
But you got to stop doing this, okay? We're easy to get along with.
But you're a very good judge.
Well, gosh, thank you. You're the first one to say that since 2002. And that's when he was in front of me as a police officer. How much time do you need? Now listen, here's the deal. I'm going to let you make your own payment plan. What a great country. You can put the robe on.
I could pay $30 every 2 weeks.
Okay, but what are you going to do if you don't have the money?
Oh, no, I can pay $30 every.
I know, but if you don't have the money, your car blows up, who knows? 30 bi-weekly beginning when? Tell me the start date.
What's the date today?
July 29th. So if I made it 2 weeks from today, that'd be August the 12th.
That's perfect.
Are you sure?
I'm sure.
I'll make it August the 15th. Now, if you don't have the money, what are you going to do?
Call.
You can come up here on or before the due date at 8:30, or you can call them, we'll go on Zoom, okay?
Thanks.
Good luck. Just don't ignore me, please.
I will not, sir.
All right, Shanice Deanna Wright, 254B7050112 FY.
Sherwood Haynes, Shanice, right?
How you doing, Mr. Haynes?
I'm doing well, Judge. How are you?
All right, good, thanks. Ma'am, your name?
Shanice Deanna Wright.
Detective, your name?
Good morning, Your Honor. Detective Crystal Tulas, Brownstown Police Department.
All right, so she's defendant 2. She has 1 count of UNP. How is she going to proceed?
We'd ask the court to read the charge.
Ma'am, I'm going to read your charge to you. It's contained in the complaint. It is alleged that you did, on or about December 28 of 23, utter and publish as true a certain false, forged, altered, or counterfeit instrument, deed, record, or other writing with the intent to injure or defraud, knowing the instrument was false, altered, forged, or counterfeit. It's more fully described as a check dated December the 19th of 23 in the amount of $329.59 drawn on Bank of America, naming you, Shanice Wright, as the payee, and the drawer or maker was Advisacare. That is a 14-year felony. Do you understand the charge and the possible penalty, uttering and publishing?
Yes, Your Honor.
You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. You have the right to your lawyer not only today, but at all subsequent court proceedings. You have the right to a lawyer. If you cannot afford one, you can apply for one at public expense. Also, if you choose to submit the questioning with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand everything I just said?
Yes.
You have the right to a probable cause conference within 14 days. Your lawyer, the new lawyer will appoint you. If you can't afford one, will speak to the prosecutor. If you do that, if it doesn't resolve at that point, we're going to proceed to a preliminary examination. At the preliminary exam, as to this 1 count, count 2, the people have to show that the crime was committed and that you were the one who probably committed the crime. If they prove that, you'll be bound over for further proceedings to the Wayne County Circuit Court. If they fail to prove that, the case would be dismissed and you would be discharged. Do you understand that?
Yes, sir.
All right. So I'm going to give you August 12th at 9:30. That will be your PCC. You'll be in front of Judge Hessen, your probable cause conference. And your preliminary exam will be August 19th at 11. So August 12th at 9:30 in front of Judge Hessen. August 19th at 11 o'clock in the morning in front of Judge Hessen. Detective, I just want to ask a question before I have Mr. Haynes address bond. Was this presented to the Brownstown Liquor Store at 18427 Telegraph?
Yes, Your Honor.
All right. Counsel, what would you like to say?
Judge, this is an older case, but it would appear that Ms. Wright has not missed any court dates, so it's like the complaint wasn't issued until almost a year after the alleged offense date. She has a limited criminal history. I think I saw a couple of driver's license suspendeds on the record. We would ask the court to consider her personal or low-end violence. So she is employed. She's a private healthcare provider.
How much does she make there?
I think it's not.
How much do you make there, ma'am?
I work 15 hours, so my checks be about 300 every week.
300 a week? How much do they pay you per hour?
$20.
That's not bad. Maybe you can try to get some more hours out of them. She does, what does her criminal history show, Detective?
Your Honor, I don't believe that she has any prior felony convictions. The only thing that I show as of the time of this warrant application was completed was that she had 2 suspended license offenses. I believe that she has warrants for those, but aside from that, and dismissal on assaulting a police officer, I don't see any convictions.
You've had a warrant out of Southgate since 2021. You've had a warrant out of Dearborn since 2019. Why haven't you taken care of those, ma'am?
I was unaware of those. I actually just got pulled over in Dearborn and they said nothing about a warrant. So to my knowledge, that did not come up until I just got arrested.
And then they told me I had a warrant in Southgate and Dearborn.
Where do you live?
Detroit, Michigan.
Where?
On Jerry Road in Southfield in Detroit.
Can you give me your address, please?
The address in the file is the correct one, Judge.
What's that?
The address in the file is the correct address.
On Van Buren Street in Detroit?
Yes.
She just got done telling me Joy Road to Southfield, I thought. Where do you live?
16572 Van Buren Street, Detroit, Michigan.
I thought you just told me you lived in Southfield.
No, I said Joy Road and Southfield, like the two side streets. There is Joy Road and right off Southfield, not in Southfield.
All right, what are you asking for there, detective? And number one, did the department reach out to her at all after the warrant was issued?
Your Honor, we leave bond in the court's discretion, but yes, the department did make contact with her by phone to advise her of this investigation and scheduled a time for an interview. Ms. Wright, after scheduling that, failed to appear for that interview and did not respond to any contacts after that.
Did the department notify her of the warrant once it was issued?
Your Honor, this was Detective Ramsey's case. I can't say whether or not he did or did not notify
They
her.
notify you, ma'am?
No, sir. I didn't even know I had a warrant.
All right, so I want to be clear. You don't have to talk to the police, okay? But you have to show up in court. So I'm not going to hold it against you that they invited you to an interview and you didn't show up. But you make sure you show up. This is not going to be the end of the world. If you don't show up, you're going to make this a lot worse than you needed it to, and it's going to end up a lot worse. Do we understand one another?
Yes, sir.
$7,500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No contact with employees of the Brownstown Liquor Store. No contact with prosecution witnesses except through your lawyer. You're not to enter 18427 Telegraph Road in Brownstown. You cannot leave the state without consent. You can't violate a law, and you must appear in court as directed. Also, no contact at all. I'm going to try to pronounce this, Vijay Raval, Vijayraval. No contact with him. So don't go back to that store. And also, ma'am, you are not to, this was a Bank of America check, wasn't it? You're not to go to any Bank of America. Do you understand that?
Yes, sir.
You're not to go to any Bank of America branch. You understand that?
Yes, sir.
All right, now don't make this worse than it is. Show up, okay? Otherwise, I'm telling you, you're making a massive mistake. Good luck. We'll see you here on August the 12th, August the 12th at 9:30. Thank you very much.
Thank you.
Okay, I got them coming on this one. Did I call Vislity Sims yet? Jennifer?
You did, but Mr. Barta was in a breakout room. He's back now.
F1 versus Vlacidia R. Sims, 2501326. All right, Mr. Barta, your appearance?
Good morning, Your Honor. Suzanne Barta, P65425 on behalf of the plaintiff.
I don't see her out there, is she?
I have not had her check in, Your Honor.
You can go ahead and take a default. It was scheduled for 9:30 and it is now 10:30. Go ahead.
Your Honor, it's damages in the amount of $3,846.37 plus court costs of a $75 filing fee and a $50.07 service fee. We would like to submit that default.
125. Your costs are 125.75, is that right?
125.07.
125.07, I'm sorry. So your total here should be 3971.44. Is that right?
Yes, there's always a question as to whether we're going to put the e-filing fee on there or not. And to be honest, I don't know. When we requested that, now that we have filing fees and when we have a filing fee for $75, you guys charge us $2.25.
Oh, I get it. Well, I think you're entitled to those. I wouldn't deny that.
I just don't know if we actually include them in there or not, so.
So what do you want to do? It's a big decision, $2.25. You can't buy a Diet Coke today or something.
That's fine, that's fine, we will include that as well.
All right, 397144, you can submit your default. Do you have another one?
I do.
Which one?
I have Bank of America versus John Washington.
Bank of America versus John Washington, 2501095.
Good
He's
morning,
here.
Your Honor. Cezanne Barta, P65425 on behalf of the plaintiff.
Good morning. Come on up here, sir, if you would, please.
Your Honor, I had a chance to speak to Mr. Washington before today's date. He also has reached out to our law firm through his debt consolidation firm. We've actually resolved it. He's actually made 3 payments with a 4th one upcoming. So we just need to get him a signed conditional dismissal for signature.
Your name, sir?
John Washington.
What do you want me to do? Adjourn it?
Yeah, and I would respectfully request maybe 45, 60 days, just because when you deal with a debt consolidation firm,
I know.
doesn't
I get
run
it,
smooth.
but Lisa or Jennifer, give me, listen, I don't care who you have represent you, but get them going, okay? You know what I'm saying?
I've been making monthly payments.
No, I'm not blaming you. I'm not blaming you at all, sir. I want to be clear about that. But he's saying, you know, these debt consolidation companies, they typically move a lot slower than I would, okay? I'm going to give you till, let's set it the very first civil docket in September, Lisa, Jennifer.
September 2nd, which is the day after the holiday, or do you want to go to the 16th?
Let's give me the 9th. Can I do the 9th? Why can't I do the 9th?
You have probation. We can add it on the probation
9th
docket.
at 8:30, okay? September 9th at 8:30, all right? But yeah, get with Mr. Barta and hopefully you'll submit a conditional dismissal so you don't even have to show up on that day, okay? Wish you luck. Thank you, thank you. Any others?
Nope, that's it.
Have a good day, thanks.
Thank you.
All right, ABC Auto Finance versus Brandon Michael Lively, 17B3702.
Good morning, Your Honor. Robert, plaintiff P69250.
You're cutting out badly.
Oh, sorry. Robert Zelinski on behalf of plaintiff P69250. Is that better?
Yeah, that's a lot better. Is Brandon Lively here?
I have not had him check in with me, Your Honor.
So he hadn't paid. You guys started garnishing wages. Now he wants $150 a month, right?
Right.
And you want at least $350 a month.
Well, I did when I filed that, Judge. I've been doing this 20 years. I've never seen a larger gap between what a defendant's requesting and what I've received. In just 1 month, I've received $1,900. And we had a
You're cutting out
garnishment
again. 19 what?
$1,900. We've gotten almost $2,000 in 1 month after I filed that response. I mean, one he's paid weekly. Like on the 25th, we got $529. 1 week on the 1st to $719, averaging about, the garnishment's averaging, bringing in about $475 a week. So, you know, I was looking to hopefully discuss that, get some kind of agreement with him, but I put that $350 down before based on what he put in his motion, but based on forgetting, I'd have to say something like $800 minimum per month.
The garnishment's still in effect, right?
Yeah, it's still going. Yeah, like I said, I just got.
He did not file an objection to garnishment, right?
No, he just filed a motion for payment for the $150 a month. I served him with that, heard from him, but yeah, it's significantly more. More stated, he earned more, significantly more than he earns states in his motion.
Well, what do you want me to do? I mean, I don't want to give you more than you requested in your pleading here. But then again, you still got an objection. I'm sorry, you still got a garnishment in effect. He didn't file an objection to garnishment. And honestly, I have to tell you, I don't feel real sorry for him. He hadn't made a payment since 2019. So if you want, I will simply deny his motion for installment payments and keep the garnishment in effect.
That's what I would ask for, Judge. Yeah.
Okay, that's what I'm gonna do. Plaintiff, I'm gonna just indicate defendant failed to appear on motion for installment payments. Garnishment in effect. Had not made a payment since 2019 until the last month or so, right?
Right.
Is that true?
That's true, yes.
I don't know where you are, but we're gonna have to have a better connection next time, okay? Plaintiff's motion, plaintiff's motion for installment payments denied. That was already set aside, right? I would have had to set that aside to issue the garnishment. I'm sorry, defendant's motion for installment payments denied. I had to have set aside the, Jennifer, would you check that?
Let's see, Judge, showing.
Counsel, did you guys would have had to have filed a motion to set aside the installment payment order in order to issue a garnishment?
Well, I can tell you, Judge, this file had a prior attorney on it. I don't know that might have slipped through the cracks. I can look back.
Judge, there was an order entered January 14th of 2020 to set aside the payment order.
Say that again.
January 14th of 2020, there was an order to set aside the payment order entered.
Okay.
Okay. And then you started garnishing wages recently and he started paying, right?
Right. Yep.
All right. Okay, so that's what I'm gonna do. I'm simply gonna deny his motion for installment payments and you can put garnishment to remain in effect. You can indicate everything in there, okay?
Judge, I have an order prepared and I'll send it to your box.
Well, I want to make sure this is a little bit different. I want him to make sure he submits this with all this in here, okay? Will you do that for me, Mr. Zelinski?
Yeah, you want me to submit the order denying it? And
yeah. I mean, I don't know what you have down there, Jen.
I have the scale form that the box is marked that the motion's denied.
Okay, then submit that and I'll be happy to sign it. That's good. She's going to take care of it. Okay, thanks. Thank you. All right. That comes back. Granite Televalley versus Quillen, Roy and Melissa Quillen, 501791. Is this going to trial?
No, Your Honor, defendant is not here.
Well, then go ahead. Come on up here. Your appearance?
Thank you, Your Honor. Michael Burns, P87855 on behalf of the plaintiff.
87 what?
87855.
What are they up to?
They gotta be close to 9, Your Honor.
I think they're over 9. Anyway, what do you want to do here?
We just asked for a default judgment. This is a termination of tenancy for just cause on a manufactured home, Your Honor. We've had several hearings. The original trial date was actually adjourned to accommodate some schedules, and the court was very generous in that. But the defendant.
You know they're going to probably end up filing a motion telling me something, right?
They may, Your Honor, but I've got information from my client that he's actually moving out from the home.
Writ date you're going to ask for in 10 days?
10 days, Your Honor. He plans on being out by the August 4th. We'd also ask for costs of filing.
I'm going to give you a writ date of August the 8th. You didn't seek money damages, did you?
No, Your Honor, but just costs for the filing.
Who can do that? I can't give you that. Where are you coming up with this? How can I give you that? No disrespect.
It doesn't hurt to ask, Your Honor.
No disrespect, but I just can't do that. Writ date will be August the 8th. Thank you very much. Have a good day.
Thank you.
Thank you. All right. Let me see here. What do I have? TD Bank versus Kristen Gazdecki. Mr. Mall, which one other one do you have? I got papers all over the place here. Which case?
It's hard to pronounce. It's Elzo.
Elza Holly Medical.
Thank you.
It's a 21. It's probably in a file jacket, Your Honor.
All right. Let me take this one real quick. TD Bank versus Kristen Gazdecki, 2502123.
Good morning, Your Honor. Jessica Kelly for plaintiff.
Good morning, Ms. Kelly. Where is Ms. Gazdecki? Your name, ma'am?
Kristen Gazdecki, I am on Zoom.
Good morning.
Good morning.
Did you two talk?
We
Yes,
did.
We had an opportunity in a breakout room. The parties have agreed it's not a matter of what is owed, but rather how it will be repaid. We talked about the options for that, but we do need a little time to work out the paperwork. So at this point, we're asking for a scheduling order.
Nah, you guys can do that in 2 weeks, right?
Ms. Gazdecki, do you think 2 weeks is reasonable?
Yes.
Adjourn 2 weeks, Jennifer. August what?
The 12th.
At?
10 o'clock.
At 10 o'clock. So I'll ask you to get with her and hopefully submit an order today, right? Or tomorrow or the day after. If I say today, you'll do it within 2 weeks, right? Have a good day.
Thank you. Thank you.
See you. Thank you very much. All right, LVN
Okay.
is Jimmy Rose, 2502206. Is Jimmy Rose here?
No, Your Honor, I've not had the defendant check in.
Is, who's here?
Ryan Mullally, P88457, representing LVNV funding.
All right, you want to default?
Yes.
Go ahead and give me the figures and we'll default.
Damages in the amount of $1,499.24, filing fee of $56.65, service fee of $47.29, a statutory attorney fee of $75 for a total of $1,678.18.
Defendant failed to appear, default judgment will enter. Relief requested will be granted. Judgment of default in favor of the plaintiff and against defendant, 1678-18. You can submit your order for the record. This case was scheduled for 10. It is now 10:44. You should be all set. Thank you.
All right, thanks, Your Honor.
Elza Holly Medical Consultants, MD versus Carmita Davis, 21W 728.
Good morning. Ed Mall, MAHL, P271115 for the plaintiff. Your Honor, this is the defendant's motion to set aside a garnishment, but this case has been resolved by the garnishment and the satisfaction of judgment has been filed with the court.
And Ms. Davis is not here?
Correct.
All right. So plaintiff's response, I'm sorry, defendant's objections to garnishment, just for the record, dismissed, denied, she failed to appear. And then you're saying the judgment's satisfied.
It's on the way to the court.
And then satisfaction of judgment will be filed as judgment satisfied. True?
Correct.
Boy, that was a lot to have to wait for 12 seconds. Have a good day, Mr. Mull. Nice to see you. Okay. Okay, let's take Capital One versus Biscuit, 2501643. There you go. Can you come up here, sir? I'm not quite sure how I'm going to handle this. I'm not sure he's understanding everything, Ms. Palmer. Sir, you can have a seat right there. How you doing, Mr. Biscuit?
I'm starting to wake up, sir.
Wake up? Yeah, I'd like to wake up. It's 10 to 11. But I've been up since 6, so that's okay. All right. Do you understand everything that's going on here?
Yes, sir.
Do you?
Yes.
Do you owe this debt?
Pardon me?
Okay, now listen, we're going to correspond. I'm going to keep my voice up nice and loud. Do you owe this debt to Capital One?
No, I don't. I I never used their card.
But you didn't really deny it in this answer. You say, I might have bought three pair of Dockers, 2 pair of pants, light jacket, and pajamas. Counsel, do you have any of these bills?
So we have,
bills from Capital One?
yes, so we do have 12 months of statements, but it doesn't have the transactions he was making, but it does show the payments being made. So during that 12-month period.
Sheriff Povich, you have to take your head off, please.
Sorry about that.
It's okay. So, all right, so it shows payments, but no transactions, purchase transactions.
No, we don't have back that far, no. Now, my understanding, and you know, obviously, this information was elicited from the group when I was in the breakout room, but my understanding was the position about the published clearinghouse was that has put them in an insolvent situation where they do not have any money.
That's pretty clear reading this.
Yeah.
And as you know, you can't garnish or attach Social Security benefits.
Right. And I did indirectly, obviously I'm not their attorney, but I did indirectly talk to them about the methods of collecting on a judgment. And I mean, a judgment is only a judgment. So,
can't commingle your Social Security benefits with other funds and have them protected. Okay? If you're collecting Social Security and that's the only thing you have, as long as you don't commingle them, if you have them put in a separate bank account, they can't get at those. Okay?
I retired from Ford after 39 years. And then I get that money from them, and then I get the security of
I don't know what you want me to do, though. What do you want me to do here, Ms. Palmer? I got a motion for summary disposition. I've got a gentleman telling me this isn't his debt. I was told by somebody else that he's got.
I was notified, sir, can I start?
Absolutely.
I was called by the people in New York had called me and they said that if I work with them, they'll give me this, and it was $100,000. And a few other things like.
You know what? I wish I was a circuit judge and those characters came in front of me. I'd give them every single day I could.
That was.
Just preying on elderly people. It just makes me want to stick the fat end of a ball bat down my throat.
This goes back to 2.5 years. I've worked in different areas and I had some things that I won.
Yeah, they scammed you.
Put up on a wall, and the person that was.
Did you make a police report?
No, I did not.
Why not?
I thought that there was two.
Listen, I want you to listen to the wife of the